Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Just wanted to hop on in here because I see that there are a few channels that are, have shows tonight, so I do want to be respectful and ensure that I don't overlap them because I want everybody to be able to, go and watch their content. So I wanted to get mine out the way and go be nosy with y'all. So as y'all can see by the title, by the thumbnail, this is in regards to Megan the Stallion's ex-cameraman. I'm not really into celebrity lives, so I'll be oblivious to things that happen. And so I never knew that her cameraman ended up suing her. And so I read a little bit of the complaint of, so there's two things that's going on. I'm going to read you guys the initial complaint that was filed in May of this year. Since December 23rd, the court actually granted the plaintiff his motion for leave in order to amend the complaint. And in reading what is going to be submitted, it adds a little bit more detailed and context along with other causes of action. So if you follow me on Instagram or you look on my community wall, you will see the additional causes of actions that has been amended into the initial complaint. But this is my first time. I don't know if you guys have heard this anywhere else. So this is my first time actually reading this initial complaint. But we all are about to be, if this your first time, this is my first time too, and we all gonna be in shock, okay? All right. So let's hop right on into it. Definitely don't forget to hit the like button and share. I'm gonna try not to take too much of you guys' time because I want to be done by 6, so that way y'all can, get your food or your snacks or your wine or whatever, so y'all can hop on to the other content creators' channels to watch their lives. And I'm sorry if you hear my child in the background. So between the weather in Texas and Spectrum Internet, I don't know what's going. I got the top speed internet, and the kids still are hollering. They're lagging. So bear with me. All right, so this is Emilio Garcia. He is the ex-cameraman for Megan the Stallion, and this is the initial complaint that was filed in Los Angeles, initially, for a numerous amount of things that as you can see here on the right side. So he ended up suing Rock Nation, Hot Girl Touring Company, Megan the Stallion Entertainment, and her as an individual. So pretty much the label, her and her businesses. Okay. He sued them for a hostile work environment and harassment, failure to prevent let me, where's my notes, failure to prevent and remedy the harassment, a numerous amount of violations of the labor code and the California labor code. And y'all gonna be, if y'all look at this, look, misclassification, meal and rest breaks, unpaid overtime, inaccurate wage statements, waiting time penalties. He also included retaliation as well as the violation of the California Business and Professional Code. So I don't, child, look, wait till we start listening to this and y'all gonna see exactly what happened. Now, I am a Meg the Stallion fan. I do like Megan the Stallion, but I do be wondering about certain things that I have read in this complaint, amongst other things. So, I mean, just don't take, like, if I say certain things, don't take it to heart. I'm reading it as if I am in my capacity as a paralegal. So it's going to be, non-biased, but I do like Megan, don't get me wrong. But just know that whatever this complaint says, I'm going to explain it and I'm going to give my raw reaction to it. All right. Now, he is demanding a jury trial, which is good. Um, Ooh, let me put my trigger warning. Well, you know what? First, before I even get this is the initial complaint. Nope, I'ma wait. I'ma wait. But let me put this cause child. All right, all right, all right, all right. So we have Emilio Garcia, da 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 da, jurisdiction, parties. Let me see. Let's get down to the facts. All right, factual allegations. Y'all gonna be flabbergasted. All right, on or around June was that 2022, plaintiff was traveling on tour with Stallion in Ibiza, Spain. After a night out, plaintiff Stallion and three other women were riding in an SUV together. Suddenly, Stallion and one of her other women started having relations right beside the plaintiff. Plaintiff could not get out of the car as it was both moving and he was in the middle of nowhere in a foreign country. Plaintiff was embarrassed, mortified, and offended throughout the whole ordeal. So, bro, they if you read it between the lines, pretty much they was going at it. All right, so he's the only male, and the rest is female, and they going at it in the car. And he was terrified. The following day, Stallion inquired whether plaintiff was in the SUV the previous night. Plaintiff confirmed that he was in the SUV. Subsequently, Stallion instructed, "Don't ever discuss what you saw." Stallion berated and directed her fat shaming comments towards plaintiff, such as "fat B," "spit your food out," and that "you don't need to be eating." What's up, Buttercup? What's up, girl? After confiding in the makeup artist, Stallion learned of the plaintiff's contemplation of quitting due to Stallion's possessiveness combined with a lack of appropriate pay for the amount of time asked of him, as discussed fully below. Later that night, Stallion drunkenly FaceTimed the plaintiff, and after plaintiff expressed his belief he was being underpaid for the amount of hours actually asked of him, they reached an understanding, with Stallion affirming we're good. Despite the conversation, plaintiff remained scheduled for Stallion's upcoming gig the following Friday. This ain't looking good already. This ain't looking good, and I'm just thinking about the Milagros lawsuit, and oh my gosh. All right. Nevertheless, on or about 2023, Rock Nation unexpectedly reached out to plaintiff the night before the scheduled Friday gig and informed him that his services was no longer required by Stallion. Plaintiff has timely filed a complaint of discrimination with the California Civil Rights Department and obtained a right to sue letter on April 12, 2024. As such, plaintiff has exhausted his administrative remedies to pursue claims under the Fair Employment and Housing Act. So, uh, okay, before I even get into the violations, they amended the complaint to actually include discrimination, retaliation, and whistleblower. But I'm just waiting for it to get filed before I cover that amended complaint, and then we can review the other additional causes of actions that was added. So this is pretty much a discrimination and unpaid wages type of suit that we're seeing here, which does not look good. They already mentioned in the beginning that she was drunk and she was having relations with women in the car while the plaintiff was in it. It's all bad at this point. So now here's the thing. I don't know how it works in the entertainment industry when you're under a label. So I don't know if, Megan the Stallion is the one that's supposed to pay him, or if it's the label, Rock Nation. So that's probably why he's also suing Rock Nation. Cause look, y'all pay Megan and Megan didn't pay me, or y'all supposed to pay me and Megan. I don't know. Let's hop on into it and see. All right, so wages and hour violations. So, from the inception of his employment, Plaintiff Garcia was misclassified as an independent contractor while working as a personal cameraman to defendant Stallion. Plaintiff has been treated as an independent contractor by Rock Nation and Stallion Entertainment so that he was effectively denied any of the protections an employee would have under California law. Oh, that makes sense. In April of 2018, the California Supreme Court, in the now infamous Dynamex decision, ruled that companies must successfully meet the three-pronged ABC test in order to lawfully classify someone as an independent contractor for purposes of wage order claims. Let's see. The ABC test requires an employer to prove the following to justify independent contractor classifications. So, in order to be determined a independent contractor, you must be classified under the following: the worker is free from control and direction of of the hiring entity in the performance of the work, both under the contract for the performance of the work and in fact. B, the worker performs work that is outside the usual course of the hiring entity's business, and C, the worker is customarily engaged in an independently established trade, occupation or business of the same nature as the work performed for a hiring entity. I think that's everywhere because I'm considered an independent contractor. I contract myself to law groups, so I don't get the benefits and all this other stuff. I'm not treated as an employee. I set my own hours. Hmm. This is gonna be interesting. So Buttercup says she's technically not under a label anymore after she was able to leave Carl Crawford. She could finally be independent. Rock Nation is just managing. Gotcha. Oh, thank you for turning in, girl, because I don't be knowing. Thank you, girl. All right, so on September 18th, 2019, California Governor Gavin Newsom signed Assembly Bill 5, which commonly referred to as a gig worker law. AB 5 codified Dynamex ABC tests under the soon to be added Labor Code Section 2750.3, which creating a rebuttal a rebuttable presumption that a worker is an employee unless the test is met, and explicitly exempt certain trades and professions. Neither the plaintiff or defendant were exempted under AB 5.1. All right, so let's see what's going on. On or around July 2018, Plaintiff Garcia supported defendant Stallion as a personal cameraman. On or around September 2019, Plaintiff Garcia quit his full time job and began his employment with defendant Stallion as a full time personal cameraman. Well, if that is the case, because now I'm thinking if you're going to become an employee, that means you need to be filling out what is that W-4 form and get benefits and all this other stuff. For all relevant time, Stallion controls and directs the work performed by plaintiff. For all relevant time, Stallion controls and dictates plaintiff's work environment. For all relevant time, Stallions controls and direct work performance of plaintiff who manage no people. For all relevant times, plaintiff essentially worked during all waking hours of the day. He was always answering calls and running other tasks under Stallion's direction. Plaintiff used his personal device to stay updated on his schedule, which blurred the lines between work and personal time for plaintiff. That's why you need two phones. More than once, Stallion interrupted plaintiff during dinner and demanded that he immediately shift his focus to assist with her TikTok creative ideas. Plaintiff stepped away from dinner and worked on the phone in a quiet space of a given restaurant. What? I know she ain't bossy like that. Oh my gosh. And but this ain't your personal assistant. This is your personal cameraman. As a personal cameraman, plaintiff was forced to take a myriad of duties and work much longer hours. Specifically, plaintiff worked in excess of 50 hours under the close scrutiny and explicit discretion of Stallion, who continuously contacted plaintiff at all hours, directing him to brainstorm TikTok videos to edit content that plaintiff had not captured and complete various assignments. That's ridiculous. He was literally getting paid under the table or doing it under the guise of being a friend. That's wild. For all relevant times, Stallion controls and direct the performance of plaintiff's work, who does not provide personal cameraman services independently of his relationship with Stallion. Stallion specifically told plaintiff he was not allowed to service any other client other than herself on more than one occasion. Initially, plaintiff was paid a monthly flat rate of $4,000 while working for Rock Nation and Stallion Entertainment. However, on or around August 22nd, Desiree Perez, which is the CEO of Rock Nation, personally contacted plaintiff to alter plaintiff's compensation structure from a monthly rate to a pay per task system invoice for each assignment. See, no. Despite this change, the time expectation of the plaintiff remained the same as before Rock Nation's demand to change plaintiff's pay. Hey, Legally Lock. This is actually, I am going over the initial filing for May. I do have the amended complaint, but I'm not going to discuss that until um, they actually file it. So, anytime if they file it before the 10th, then I'll go ahead and I'll do another video. But I'm just trying to get a feel as to why he sued Megan, because this is my first time seeing it. So this is an old filing. This is an old filing, but I do have the new filing though. But I'm just giving the plaintiff time to file it because it was just approved for the complaint to be amended. And so once they file it, then I'll go ahead and and that will probably be sometime next week. I'll do another live and we'll go over the amended. But I will read the first page of the amended complaint so you guys will know. All right. Let's see. All right. So, however, the new invoicing system resulted in plaintiff earning significantly less as the invoice amounts did not accurately reflect the true time and effort dedicated to working for her. That's messed up. Keep up the good work. Keep up the work. I love your chat. Thank you so much. Thank you. Thank you. Thank you. Thank you. All right, so let's see what Megan did. On multiple occasions, Stallion explicitly directed plaintiff not to engage with other clients, expressing possessiveness over plaintiff's services as her personal cameraman. Red flag number one. For all relevant times, Stallion controls and direct plaintiff's work performance, requiring his constant availability by phone for work-related issues, thereby causing severe emotional distress and anxiety for plaintiff. During his travels with Stallion, plaintiff was required to stay at a hotel and be on standby at all times. Any attempt to use hotel amenities would prompt Stallion to reach out and request his immediate return. That is ridiculous. As a result of the misclassification, the plaintiff was denied a meal break or rest break. In addition, plaintiff was not paid meal or rest break premiums during his entire employment. So you telling me that this man worked nonstop, didn't get no rest, didn't get to eat, but had to be at Megan's side at all times? Megan, you deserve to get sued. You deserve to get sued. For all relevant times, Stallion controls and directs the performance of plaintiff's duties not to qualify him exempt for purposes of overtime law. Oh, that's messed up. During the entirety of his employment with Stallion, plaintiff was denied overtime pay at an overtime rate. Plaintiff was not paid for hours worked in excess of 8 hours in a day. For all relevant times, plaintiff was not paid time and a half for any overtime he worked or paid after the paycheck was thus underpaid for all hours worked to the extent the pay did not meet labor code requirements. Mind y'all, he was working 50 plus hours in a week. And then on top of that, whatever uh finance system or accounting software Rock Nation had, it changed his rate from that monthly $4,000 to, being paid per task, which resulted in him earning even less. I would run, baby. I would have sued. When did baby? I don't even know when he was fired, but I would have the day after. And that's normally what happens. So a lot of people think they can just go right into suing and your employer, and you can't do that. Everybody has the EEOC or some a department that handles, labor. I know in Texas we call it the EEOC, the Equal Employment Opportunity Commission, and they will investigate. And if they find that your employer was in the wrong, they will give you a right to sue letter, and then you could go ahead and you can file your lawsuit. The thing with that is there are not a lot of attorneys or firms that are willing to take on these type of cases when you're dealing with worker related work termination. What am I trying to say? Wrongful termination cases. There you go. There are not a lot of attorneys that like to do that because they want to see that they're going to benefit from that they're going to get a huge settlement. I'm just throwing that out there. All right, let's see. Da, 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 da. All right, so during the entirety of his employment with Stallion, plaintiff hours of employment were not properly recorded due to the purposeful misclassification of plaintiff as an independent contractor and inaccurate work records controlled by defendants. So you put him on the monthly rate, then you changed it. He worked 50 hours plus per week, but yet you're still calling him an independent contractor, and you're now it says inaccurate work records. I believe y'all falsified the work records to not pay this man what he's supposed to get paid. Moreover, during the entirety of his employment with Stallion, plaintiff was denied his meal and rest breaks and compensation for overtime hours worked, subject to inaccurate timekeeping by Stallion, which resulted in inaccurate wage statements. Stallion's misclassification of his employment status left him without basic insurance coverage, depriving him of essential health care. Plaintiff grapples with mounting anxiety, depression, and physical distress stemming from toxic work environment, of compounded by the trauma of unpaid work. That's crazy. So he has sued her for a numerous amount of things, y'all. There's a lot of causes of actions. He has sued her for a hostile work environment, a failure to prevent remedy in harassment, the violation of the labor code as well as the California code. And then it breaks down each little part of it. Now, I'm not going to read every single thing, but I'm going to touch bases on some. So the first cause of action was hostile work environment, which was against all defendants. So that Rock Nation, Megan as an individual, as well as her entities. Um, so it says defendants Stallion's conduct created a hostile work environment for plaintiff, making the hold on, my child is hollering, he getting on my nerves. Boy, just hollering. Sorry, y'all. Defendant Stallion's conduct created a hostile work environment for plaintiff, making the conditions of an employment intolerable in direct contravention of various statutes and state law decisions, including but not limited to the California Government Code. So he began his employment in 2018 as a personal cameraman. June of 22nd, he traveled to her to Spain, and after one night, he was in the car with other women, and she began to have, relations, and that made him feel very, very comfortable. The day after, Stallion asked him if he was in the SUV. He said, "Yes, I was in the SUV." And she said, "You better not ever discuss what you saw. That's a threat." During the same trip, she ended up berating him and directed her fat shaming comments towards him, calling him a fat bee, telling him to spit out his food, and you don't need to be eating. Now, I saw a picture of this man. He doesn't even look big. I'm confused. Following the Spain trip, let's see, Perez, so the CEO of Rock Nation, altered his compensation structure from a monthly rate to a pay per task system. Let's see. Despite this change, plaintiff remained accountable and was expected to provide the same level of service to Stallion. Moreover, plaintiff noticed a change in how he was treated and saw a decrease in the number of bookings he received from Stallion. Close to other creatives on Stallion's team, plaintiff confided in Stallion's former makeup artist about considering leaving because Stallion had started to hire another cameraman. So he wasn't getting, man. So this dude then quit his full-time job to work with Megan full-time, only for them to switch up the pay system and book him less and less and less, which means he's not generating the income. He was already getting, beat over the head out of getting paid, but now you're not booking me. And then on top of that, you hire another cameraman. You should have started trying to find another job. Ain't about to mess up my bag. Such harassment was so severe or pervasive that it altered the terms and conditions of plaintiff's employment, creating a hostile, abusive work environment and making his working conditions intolerable. Said harassment was sufficiently extreme to the amount to a change in the terms and conditions of plaintiff's employment. What he's seeking? Let's see. He is seeking. Oh, wait, hold on. He suffered and continues to suffer general, consequential, and special damages, including but not limited to substantial losses in earnings, other employment benefits, physical injuries, physical sickness, as well as emotional distress, plus medical expenses, future medical expenses, and attorney fees, all to her damages in the amount according to proof. And that's supposed to be his damages. I don't know why they said her. During the entirety of his employment with Stallion, plaintiff endured a barrage of relentless, exual, and fat shaming comments, plunging him into a profound emotional distress. Stallion's misclassification left her without basic Stallion's misclassification left him without basic insurance coverage, depriving him of essential mental and physical health care. He grapples with mounting anxiety, depression, and physical distress stemming from the toxic work environment. I mean, as soon as I would have seen that I am not getting booked, you have to go hustle and find another gig to, offset the loss that you took. Especially if they put you as an independent contractor. That's why I don't stick with just one attorney, because you never know what type of week they're going to have. So, I mean, I feel bad. Don't get me wrong. And he has every right to sue them. But I'm just saying, I would not sit there and suffer. I'm going to go out and do what I need to do to ensure my bag stay, full. Do, 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 do. Let's see what else they said. So this is against Rock Nation, Hot Girl Touring, Stallion Entertainment, and Doze. So they are saying pretty much what he's saying, that Rock Nation, Hot Girl Touring, Stallion Entertainment, and other entities failed to prevent him from being harassed by Megan Thee Stallion. Let's see. Defendants Rock Nation and Stallion Entertainment regularly employed 5 or more persons, bringing defendants within the provisions of the Federal Employment Housing Act. Plaintiff was subject to harassment based on based on sex by defendant Megan Thee Stallion as alleged in more detail above. Okay, so are you saying that he was harassed based on him being a male? I think that's what they're trying to say. Under FIHA, an employer is strictly liable for the harassing conduct of his agents and supervisors. And this just kind of goes over the events that took place. What happened in Spain in the SUV, and then her telling him not to discuss what he saw, then started, calling him all kinds of names and telling him what to do. All right, so this is just saying the same thing. Same thing that we just read. Nevertheless, on or around June 2023, Rock Nation fired him right before the scheduled Friday gig. So he took a financial loss, including without limitations loss of salary and benefits and the intangible loss of employment related opportunities in his field and damage to his professional reputation. So that's very interesting because you're saying that you couldn't get another job in your field. That's interesting. A violation of labor code misclassification. So this is talking how they switched them from the monthly rate to the pay that pay per task rate. And see, that doesn't fall under the ABC test. Remember, that's what they was talking about in the beginning. So the ABC test requires an employer to prove uh, the following to justify independent contractor. So they classified him in the beginning as a independent contractor, but the reason why they're claiming that this is a misclassification is because this man was working 50 plus hours per month. And if you're considered an employee, I mean, well, not really, but it's just the level. Like if they're telling you when to work, when you can go on break and all this other time, technically you are considered an employee. Yeah, because me as an independent contractor, if I don't feel like working that day, I'm not working that day. If I feel like working 10 hours in a day, I will work 10 hours in a day. But I don't get the benefits. Nobody's going to be like, well, I need you to sit here and I need you to work from this time to this time. It doesn't work like that. So by them classifying him as an independent contractor, they get away with not allowing him to have health benefits. The benefits that a normal W-2 employee will actually get. That was their way of doing things. But yet they're telling him he got to work 50, well, not they, but Megan say, you got to do this, this, and this. You got to do this. You can't do this. That sounds like an employee to me. That's so sad. I feel bad for him. I'm not just gonna kind of scroll. Fourth cause of action, the labor code. This is the crazy part. So this is against everybody, including Megan. So failure to provide meal and rest periods. Plaintiff is informed and believe, and thereon alleged the labor code. Um, Section 226.7 and 512 were in full force and effect and binding on defendants during all times mentioned in this complaint. Says section requires employers excuse me, to comply with all industrial welfare commission wage orders governing meal and rest periods, because if you are an employee, y'all do know that they set the state, like for instance in Texas you are required to take like a 30-minute lunch or have a 10-minute lunch break, something along those lines. I can't remember because I quit my firm in 2022, so I make up my own shit. But there is a set, they do have laws that says, okay, employers can do this, employers have to allow to do this. Whew. Hey, Nina 812, what's up? What's up? What's up? Wait. Who finna hire someone else? I'm not about to play with you. That's on his Instagram. I gotta go be nosy. Oh my gosh. MTS is just bad news. Oh my gosh. I love begging, but this ain't looking good at all. I'm an old paralegal not following nonsense. However, you bring docs to layman folks. Thank you so much. Hey, hey, hey. Yes, I enjoy this. I enjoy this. I mean, it's raining outside in Texas. I'm like, why not go over this? Because I have not read this lawsuit. This is my first time reading this. So this is just news to me. And it does kind of open my eyes to see, what is going on because you only see people on the outside because we're on the outside looking in, but when you have people that are close to them, that's a totally different story. So when I'm reading these court docs, I'm blown away because I'm just like, Megan, really? I mean, I could kind of sense that she's like bossy, but this is beyond wild to me. MTS is one evil individual. Oh Lord. Oh Lord. All right. So she did not allow this man to eat or rest. He didn't get to take no breaks. Let's see what it says. So plaintiff is informed and believe and thereon alleged that the IWC wage orders were in full force in effect and governed when employers, including defendants, Rock Nation, Hot Girl Touring, Megan the Stallion Entertainment, must give employee breaks for meal and rest periods. The wage order states in pertinent part that employers must provide at least 30 minutes of meal periods for every 5 hours of work and another 30-minute period if the work period is 10 hours or more. Furthermore, the IWC wage orders state in pertinent part that employees must be given at least a 10-minute rest period for every 4 hours of major fraction thereof. See, I knew it. Oh my gosh. Oh my god. Thank you so much. Thank you. I can't oh, this is a super chat. Thank you so much for the super chat. What you say? So OG paralegal left that world. You're like me, always breaking it down to our people. Blessed returns always. And thank you so much. Yes. And it's so crazy because right now I can ask my kids something about, something about the law because they listen to me on a daily. And but I don't want them to be a paralegal. They want to be engineers. So I'm pushing them in that direction. But thank you so much. Thank you so much. Whatever I can do to break something down, I'm going to do it. I am. Because I do want a lot of people to understand what things mean because you never know when you're going to be in a situation involving, the law or a lawsuit. So thank you so much, Nina. During the entirety of his employment with Stallion, plaintiff hours of employment were not properly recorded due to the purposeful misclassification of plaintiff as to an independent contractor and inaccurate work orders. I say work orders, work records controlled by Stallion. Ooh, this is sad. This is sad. As a result of misclassification, plaintiff was not permitted to take rest and meal breaks. Many times, plaintiff worked over 5 consecutive hours without a 30-minute meal break. Plaintiff was not paid meal or rest break premiums. This action by defendants were in violation of IWC wage orders and California Labor Code sections 226.7 and 512. Mm. Amazon make you work 10 hours with a 30-minute lunch and two 15-minute breaks. Yeah, and that's depend, but I will always check with the state to see what the labor laws is because some of these employers be trying to get away with stuff. So yeah, I'm just saying just Google labor code for your state and whatever state you in and read it. And don't be afraid to stand up to these employers. Hell. Um. Okay. Plaintiff's claims for break. rest break violations, waiting time penalties, and failure to issue inaccurate itemized wage statements are claims for non-payment of wages, entitle a prevailing plaintiff to an award of attorney fees under the California Labor Code. So if they determine that they were in violation, they have to award them attorney fees under the California Labor Code. And see, that's the way that they filed this, I love it because they're not only getting them for like the labor code as far as overall, the federal, but they're getting them specifically for their state. That's awesome. Moreover, defendant Megan Thee Stallion is personally liable for violations mentioned herein under Labor Code Section 558.1, as she was the natural person who is an owner, director, officer, and managing agent of the employer acting on the employer's behalf for said violations of plaintiff rights. Because I don't know how it works. Once again, I'm not a celebrity, so I don't know how they pay or track hours for an individual. And that if they don't have something in place like that, I suggest that they need to do that, because if not, they're going to see a lot more lawsuits out there. I'm surprised. I wouldn't be surprised if there, isn't a lot already. I just haven't checked, but this is unacceptable. This is unacceptable. He's suing for unpaid overtime. This man was 50 hours plus. Because we know once that 40 hours hit, over 41 on up, that's overtime, a time and a half. And they didn't even give this man that. He was hired July 2018. Let's see. We know that Stallion controlled and directed, whatever it is that she wanted him to do. Um, Plaintiff duties did not qualify them exempt for purposes of overtime law. He used his personal device to stay updated on his schedule, which blurred the lines between work and personal time. Y'all couldn't even get the man another phone, a work phone dedicated for that. And I'm pretty sure they didn't even pay his phone bill either. More than once, she demanded, while he's at dinner, that he shift his focus to her to help her with TikTok. I don't even follow her. I don't follow no celebrity on TikTok, so I don't even know if she even posts. Let's see. Plaintiff work in excess of 50 hours under the close scrutiny and explicit discretion of Stallion, who continuously contacted plaintiff at all hours, directing him to brainstorm TikTok videos, to edit the content, and complete various assignments. All they have to do is, when they get to discovery, pull her TikToks, all her social media. If he has not provided all his call logs and stuff like that, and they're all they have to do is look at it and see. All they have to do is just look at the timeline and see. I don't see her. I see him winning this. I really do. $4,000 while working with Rock Nation, and then so that was 2018. So August 2022, that's when they changed to the pay per task. So I want to know, what kind of task is it? Oh, this is bad. All right, so this is unpaid wages. So we know that he worked in excess of 50 hours per week. Inaccurate wage statements. Oh my gosh. Let's see it all. Da, 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 da. All right, so let's see. So under the California Labor Code, it provides that every employer shall furnish each of his or her employees an accurate, itemized wage statement in writing showing 9 pieces of information. So when we get, those pay statement, well, not we, but I know when I used to work and I get those, it should show your gross wages earned, total hours worked by employee, the number of piece rate units earned, and any applicable piece rate if the employee is paid on a piece rate basis, all deductions, provided that all deductions made on written orders of the employee may be aggregated and shown as one item. Net wages earned, the exclusive dates of the period for which the employee is paid, the name of the employee, the last four digits of his or her social security number, and or the employee identification number other than the social security number, the name and address of the legal entity that is the employer, and all applicable hourly rates in effect during the pay period and corresponding number of hours worked at each hourly rate by an employee. So if all of that is not shown on your pay stub, y'all need to be questioning y'all employer. It might be some shady stuff going on. So does UPS Trust. We have no employee right. Wow, no HR on site. What? We are a union and our medical docs are processed by non-professional. What? They play on military units too. That's interesting. That's very interesting. So let me ask you this. So if something was to happen, and you know how they always say HR has like an open door policy, blah blah blah. So if something happens, you guys couldn't go to HR. You have to go to the union? Because that's interesting. All right. So they didn't even I don't even think they even gave this man any work stubs, to be honest. Oh, the defendants intentionally and willfully failed to provide plaintiff with complete and accurate wage statements. The deficiencies include, among other things, the failure to include the gross rate. Okay, so everything that I pretty much said, and the failure to accurately list all applicable rates, as plaintiff was not allowed to take rest breaks and late or no lunch breaks when the law required the same. Because if he's not taking any breaks, that means his check should be good. His check should be awesome. Yes, I need federal lawyer assistance referral. Yes, the union. Oh, ooh, golly. That just seems like that's a difficult process having to go through all that. So yeah, so they didn't even give this man his pay stubs to even see, how many hours he worked, how much he made, and how much taxes y'all done took out. And that has to be itemized. So yep, that was in one of Diddy's cases too. I need to see that. Furthermore, plaintiff claims for rest break violations, waiting time penalties, and failure to issue accurate itemized wage statements are claims for non-payment of wages entitle a prevailing plaintiff to award uh, of attorney fees under the California Labor Code. Baby, Megan, you about to get hit all kinds of ways. Well, not just her, Rock Nation, because it does say against all defendants. Waiting time. Let me see. What does this say? At all times under the California Code, provide that if an employer discharges, so if an employer discharges an employee, the wages earned and unpaid at the time of the discharge are due and payable immediately. And if an employee voluntarily leaves his or her employment, his or her wages shall become due and payable it's supposed to be no later than 72 hours thereafter, unless the employee has given 72 hours previous notice of his or her intention to quit, in which the case the employee is entitled to his or her wages at the time of quitting. Y'all didn't pay up. So when they fired that man before the that event, they didn't give him his last check. Mm-mm. And now I'm summing it up for y'all, so we ain't got to read all this. Another violation of labor code. I mean, this is all self-explanatory because it's pretty much repeating the same thing, but just kind of breaking down the violations under each code. And then we have a violation of California Business and Professions Code against Rock Nation, Hot Girl Touring, and Stallion Entertainment and Doe's. Not Megan individually, but the entities. Defendant's conduct, as alleged herein, has been and continues to be unfair, unlawful, and harmful to the plaintiff, other employees, and to the general public. Plaintiff seeks to enforce important rights affecting the public interest within the means of the Code of Civil Procedure, Section 1021.5. Let me see what it talks about. Under the California Business and Professions Code may be predicted on the violation of any state and federal law. All of the acts described herein as violations of, among other things, California Labor Code and Industrial Welfare Commission wage orders are unlawful and in violation of public policy. In addition to are immoral, unethical, oppressive, fraudulent, and unscrupulous, and thereby constitute unfair, unlawful, and or fraudulent business practices, in which they are. You're not paying them. You're not providing them with the itemized pay stubs. You're not allowing him to take a break. You're not allowing him to rest. You're classified him as a independent contractor when you're treating him like an actual employee, which is depriving him of medical care, medical health care, and all the benefits that an actual employee will get. Paying this man nothing, having him work 50 plus hours, and you're not paying him nothing. The business, the company, Rock Nation, Hot Girl Touring, and what is it, Stallion Entertainment, y'all have failed this man, and you do deserve to get sued. Run this man his coins. And yep. So y'all have violated the California Business and Professions Code, because all of that's unfair, that's unethical, unlawful, all of the things. What is he praying for? Let's see. He wants his unpaid wages as any other person that does not get paid, for interest on the amount of the unpaid wages and other employee benefits at the prevailing legal rate, for general unpaid wages at overtime rates, and such general and special damages as may be appropriate. And this is where they're going to have to sit down and actually calculate how much this man worked. And they're not going to follow no pay per task. No, it's going to be a lot. And then they're going to add interest on that. Then they're going to add the overtime that y'all was supposed to pay this man. I hope he get every lick of, money that can be given to him. Statutory penalties under the California Labor Code. Let me see. Oh, and it's two sections. Under both of those sections, for restitution of unpaid wages. So you gonna give me my unpaid wages, but also you gonna pay me because you didn't pay me. And prejudgment interest from the day such amounts were due and payable. Punitive damages. He asking for them to pay his attorney fees, the fees to even file this lawsuit, in obtaining the benefits due to plaintiff, and for the violations of his civil rights pursuant to the Labor Code as well as the California Code of Civil Procedure. And whatever other relief the court or the judge feels is necessary, he wishes that as well. Boy, this right here. Nope, let me not. This is crazy. And I did tell y'all I was going to give y'all a preview of what they are about to file. So if you're on IG, I played the song. It was a reason why I played the song. So this is how they're starting their amended complaint with this preliminary statement. Two red bones kissing in the backseat. Girl, don't stop. Keep going and relax me. You want me to join in, then ask me. I like girls that attract me. And this is Megan's song called Best Friend. Baby. Then it reads, plaintiff was employed as Pete's personal cameraman. Unfortunately, the hypersexualized and graphic lyrics pervasive throughout Pete's music blended into the working relationship between Pete and her employees, as she subject plaintiff to unlawful discrimination, harassment, and retaliation on numerous occasions. And I ain't gonna read no more because come just give me about a good 2 weeks. So once they file it, then we'll get into this. And I'll only read the parts that they added in because we already know the reason why, he's filing for the labor code and the harassment and the hostile work environment. But if they're adding, discrimination and retaliation and whistleblowing and all that, I'll read only that so we can understand, how she was discriminating or how she retaliated. But yeah. Let me see where we at. Um okay, I'm working it are based in my paralegal knowledge. I'm confident, but is oh, so you're actually going through something right now? God, if you're going through something, hold up. Let me this is my whatchamacallit. I'm putting in the chat my actual my business email. But yeah, cuz I know when it comes to that, it's hard, especially when you don't have cuz it's hard when you just have a union versus an actual, HR department. Oof. Where did Stallion Entertainment get groomed from Jay-Z? Baby. You know what? I never thought about that because now I'm thinking about Aaliyah. Seeing Aaliyah back then in those old photos. He need to sue Jay-Z, the founder of Stallion Entertainment. That's a good question. Hey, I ain't thought about that either. Why why lyrics in legal? I'm saying you live. Okay, gotcha. But hey y'all. So I know some other content creators has started, so I'm gonna let y'all go so we can all go tap in to be nosy. Thank y'all for joining. Thank you for the super chat. It was very much appreciated. To the replay game. What's up? What's up? What's up? Thank you for watching. Y'all, tell me what y'all think about this. Like I said, I got the amended complaint. I'm just waiting for the plaintiff's attorney to file it. And then once they file it, then I can present that to you. But this is something that was new to me. It's very unfortunate. Like I said, I like Megan. I love her music, but wrong is wrong, right is right. This man does need to get paid. You can't treat people any type of way and just think that you're going to prevail. But y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.